3, 2, 1, start. The Learned Counsel for the petitioner submits that the present petition has been filed challenging the order passed by the competent authority whereby the representation submitted by the petitioner was rejected without assigning any cogent reason. It is contended that the impugned order is arbitrary, illegal, and contrary to the settled principles of law. The petitioner had placed all the relevant documents before the authority, but the same were not taken into consideration while deciding the matter. Learned Counsel further submits that the petitioner was appointed to the post in question after following the due procedure prescribed under the relevant rules. He continued to discharge his duties honestly and diligently, and no complaint regarding his conduct or performance was ever received. However, without issuing any notice or affording an opportunity of hearing, the services of the petitioner were terminated. According to the petitioner, such action is in clear violation of the principles of natural justice and therefore cannot be sustained in the eyes of law. Upon notice, Learned Counsel, appearing on behalf of the respondents, opposed the petition and submitted that the action taken by the department was strictly in accordance with the applicable rules and regulations. It was argued that the petitioner had failed to fulfill certain essential conditions of appointment, and therefore the competent authority was justified in passing the impugned order. The respondents have also placed on record the relevant documents in support of their contentions. We have heard Learned Counsel for the parties and have carefully examined the material available on record. It is well settled that an administrative authority, while passing an order having adverse civil consequences, is required to follow the principles of natural justice. No person should ordinarily be condemned without being given a reasonable opportunity to present his case. The requirement of granting an opportunity of hearing is intended to ensure fairness in administrative action and to prevent arbitrary exercise of power. In the present case, the record reveals that no show cause notice was issued to the petitioner before passing the order of termination. There is also nothing on record to indicate that the petitioner was informed about the alleged deficiencies or was granted an opportunity to explain his position. The impugned order merely records that the petitioner had failed to satisfy the required conditions without specifying the material on the basis of which such conclusion was arrived at. The contention raised by Learned Counsel for the respondents that no opportunity of hearing was required in the facts and circumstances of the case cannot be accepted. Even where the relevant rules do not expressly provide for a personal hearing, the authority is expected to act fairly, particularly when its decision is likely to adversely affect the rights of an individual. It is equally settled that reasons are the foundation of a judicial or administrative decision. Recording of reasons ensures transparency and enables the affected person to understand the basis of the decision. An order which does not disclose any reason may also prevent effective judicial review by the court. Considering the facts and circumstances noticed above, this court is of the considered opinion that the impugned order cannot be sustained. Accordingly, the present petition is allowed and the order passed by the competent authority is hereby set aside. The matter is remanded to the authority concerned for consideration afresh after granting a reasonable opportunity of hearing to the petitioner. The competent authority shall thereafter pass a speaking and reasoned order in accordance with law, preferably within a period of 8 weeks from the date of receipt of certified copy of this order. The petition stands disposed of accordingly. All pending applications, if any, shall also stand disposed of. There shall be no order as to costs. Stop.